Hello again, my name is Ernest. Let's settle for the details now. And Deputy Attorney General Godfrey Adeboadami says the EC will no longer face any legal impediment preventing it from registering Ghanaians on Tuesday. 2 cases against the EC's exercise were dismissed yesterday, with the court holding that the existing voter's ID card cannot be used for registration. There's, however, 1 case filed by NDC MP for Ashaman Ernest Nobe, which is pending at the Accra High Court and due Monday. Mr. Dami says his office will be urging the court to dismiss that case, as well as maintaining the Supreme Court's extensively dealt with, as the Supreme Court dealt with the issue, and the MP is asking the court to address the matter. We can now hear from the Deputy Attorney General.
Yes, so it says by this decision, the Electoral Commission, second defendant, is hereby directed to commence the compulsory voter registration as scheduled. Then, by these decisions as well, they proceeded that any court in which same or similar action is pending or yet to be filed shall apply the decision rendered by the Supreme Court in these cases. So no court has the option of electing whether to comply or obey this ruling. The Supreme Court has ordered in the exercise of its powers over all lower courts in the country that this decision is a final decision on the matter and must be complied with by the court.
We know they had filed for an injunction which they are supposed to move on Monday, so it means that Monday they will have to go for that. You have to go and argue that injunction before the court and ask them to abide by the decision of the Apex Court, or to place automatically they are not going to have a hearing at all.
Yeah, so this decision will be brought to the attention of the High Court, and the High Court will make an order accordingly, dismissing, in essence, all the reliefs sought. For all the reliefs sought are also in the nature of the reliefs that, or similar to the reliefs that were being claimed in the Supreme Court. So the court will not have to hear an injunction and then come back and hear the substantive suit. The presiding judge would definitely, in accordance with this ruling, proceed to issue the necessary orders, which will be on all fours as the instant action.
But going for a judicial review, is it not fair that they allow the courts to just take a look at the process leading to the decision to compile the register, which is what normally judicial review looks at, as against the interpretation and enforcement which has been carried out by the Supreme Court? Now,
the Supreme Court, under Article 129 of the Constitution, has the power to exercise all powers vested in any court at all. That we call it the residual jurisdiction, the residual power of the Supreme Court. They can exercise all powers that are lawfully vested in any court or tribunal in the country. So the Supreme Court, in exercise of the powers conferred on it by the Constitution under Article 129, has made its consequential orders, and all courts are supposed to comply. I think the essence is quite clear that there ought to be order in the administration of justice. There cannot be a situation where the Supreme Court has taken its time to adjudicate on this matter, made orders which are binding on the NDC and all citizens, and then another citizen will be prosecuting another matter in the lower court. So for the sake of ensuring order and an efficient administration of justice, the Supreme Court has exercised its powers under Article 129 and made these orders, and all courts will be required to comply.
Let's go back to our earlier story on the Supreme Court ruling and speak to a lawyer. Bernard Oredu joins us on the phone with some more analysis on this. Thank you very much for your time here on Newsdesk. I'm sure you've been looking at the Supreme Court ruling. Let me take your general impressions of the court's decision in the context of all that we've seen in Parliament and on the political front.
Well, good morning to your viewers. Let me say that I would like the viewers to understand that the Supreme Court, in taking decisions and later coming to give reasons, is very normal. They will give the decisions, their conclusions, and would say that their reasoning behind the conclusions or decisions will be given later. That's a normal happening with the Supreme Court. If you could remember, even the election petition was on those lines, where the Supreme Court gave its decision, but the reasoning behind its decision was given at a later time. So just say that it is very normal. It is a daily occurrence by the Supreme Court where a decision is given, but the reasoning is deferred at a later date.
And now we have the EC being given the green light to go ahead, but there's this gray area I want to pick your thoughts on. Some portions of the relief sought...
Back to the ruling itself. I understand the fuss on social media, especially with the interview granted by the General Secretary. But the Supreme Court has been very clear, and it was unanimous, that every registration, every person to be registered as a voter is supposed to meet the requirements under CI 126.
Okay.
If you're a Ghanaian and you want to assert your right under Article 42, you need to first be a registered voter. And to be a registered voter, you need to go by the tenets or the provisions of CI 126. So the Supreme Court has been very clear that no Ghanaian is supposed to be disenfranchised once you're a registered voter. But first, you need to meet the requirements under CI 126, which has excluded the use of the old voter ID card.
And indeed, we've had the NDC subsequently allude to that interpretation with the address that was given by the former president yesterday, except that they are disappointed in the court's decision. I'm wondering that going forward, what will happen? The deputy AG says that it doesn't look like the EC will be faced with any legal impediment. Doesn't necessarily mean so because of the Ernest Nodbe case, which is at the High Court, which the Supreme Court is directing that all related matters must be guided by its decision yesterday. Can we necessarily say that the EC is out of the woods as far as legal issues are concerned?
Yes, for now we could say that because litigation must, out of necessity, come to an end. The Supreme Court was emphatic that, of course, the Supreme Court is the highest decision-making judicial body in the country. And once the Supreme Court has spoken, it brings finality to all matters. But no one is shut from the doors or the corridors of justice. But what the Supreme Court has said that if what you seek, if the remedy you seek from any court or at the Supreme Court is similar to what has been decided on already, then the door is closed on you. Because the main issue was to whether the exclusion of the old voter register by the CI 126 was proper in law. And the Supreme Court has been clear on that yes, the laws of our land, as our constitution, gives the Electoral Commission the mandate to compile new voter register. And in compiling the new voter register, it is also their mandate to give Ghanaians the guidelines concerning the compilation of a new register. And this currently is the CI 126. So if the CI 126 has excluded the use of the old voter ID card, then that be it. So you can't come to court or you can't go to any other court seeking a similar remedy or seeking a similar declaration to that effect. And the Supreme Court has been unanimous on that. So for me, I would say as at now, the EC is out of the woods. The EC has been cleared to go about its compilation of a new voter register, unless probably another angle is being challenged. But as to the matter as to whether the old voter ID card could be used, it has been well settled. The answer is no. It cannot be used because the CI 126 has excluded it.
I want to pick your brain on this issue. So we now have the NI card and a passport as the source document. The other option is for a qualified person to guarantee for you. On the issue of a passport, if I hold a passport that expires today, but my name is in the system, perhaps I registered not long ago, but it's just expired, can I present that as a valid document?
No. An expired passport is not a valid document. That is why passports are given duration. So once your passport has been expired, then you either fall within the categories of those who could use the national ID card or those who would have to seek two people who have been already registered to vouch for them to vote. An expired document has no validity in law.
Very well. Thank you very much for your time here on Newsdesk. That's lawyer Bernard Oredu bringing us some education on the decision by the Supreme Court yesterday on the compilation of a new voters register. And with only 5 months to the 2020 general elections, legal and governance experts are advising the Electoral Commission to intensify education to engender citizen participation in the new voter registration exercise starting Tuesday. Some of them have been speaking on the AM show.
The Supreme Court was very clear that if any time the Electoral Commission decides to conduct fresh registration, the possession by a person of an existing voter's ID card that is seek to discard is a prima facie the evidence of citizenship. So why would the Electoral Commission now come to Parliament and say that a document that is good enough to determine citizenship in another process in the same country within the same period is not good enough to determine citizenship for the same process for Electoral Commission? And I speak specifically of the law underpinning the work that the NIA is presently conducting. So they keep shifting the goalposts. Their claim was that the only reason they want to discard the existing voters register is because they want to introduce facial recognition features, no longer biometric. So I don't get the point. The fact that we didn't use both existing voters' ID card before or in the previous elections in the 90s doesn't make it unlawful for it to be done now.
Still concerned about the timing. I think the Electoral Commission has tried to address some of that by reducing the number of days that the registration team will be on the ground. If you recall, the initial estimation and what we have done in normal times was about 10 days at a time. Now that has been reduced to 6 days. There's some attempt to maybe add on to the registration kits so that, we would be able to, collect the data as quickly as possible. And of course, we are doing it for a shorter period, also within the context of COVID. And so we don't know how long the process will take. Now we know protocols and other kinds of things. The estimation is that they want to 100 people at a time. The trials suggested an average of 85, but they're still pilots. And if you get in very populated urban areas where you may encounter different problems, we are yet to see. And then we also have to count in the rainy season, possible disruptions, and so on. So there's still a lot of unknown factors that would maybe shape the way the process goes. At least I know there's about 7 days that have been provided for a mop-up process. So there's still an issue of timing, because even if we are done with this process through August and definitely into September, then we are basically entering into nomination, and then, it goes on and on.
The Supreme Court has pronounced on that. That's the end. We move on to do the registration, and we get people into the register with the hope that all those other names that we don't want at the end of the day would be expunged from the register so that we'll get a clean one. It is my hope and prayer that we will get a clean register so that this tango will not be repeated in the next election. We also know that as we are going about the registration, we have COVID around our necks. We want the Electoral Commission to be very careful to take care of that so that we don't go and register only to come home to die of COVID.